Wills are an integral part of society. They facilitate the transfer or disposal of personal and real property once the owner has died. Wills are governed by states as opposed to the federal government. This consequently means that there are variations of the rules from state to state. A will doesn't just distribute property either. Wills can also appoint guardians of minor children and appoint personal representatives to settle the affairs of the deceased. Not having a valid will can lead to several consequences that may significantly impact your estate and loved ones after your passing. Without a will, the distribution of your assets may not align with your wishes, potentially causing disputes or leaving assets to unintended beneficiaries. Additionally, the absence of clear instructions in a will can result in delays, increased legal costs, and complexities in the probate process, ultimately prolonging the resolution of your estate affairs and potentially causing emotional stress to family members. An unfortunate but relevant example of the importance of wills is the case of Jimi Hendrix. Jimi Hendrix was one of the most iconic guitarists ever. He died at the age of 27. Beyond joining the infamous 27 Club, Jimi also didn't have a valid will. This is called intestate. This is when someone dies without a will. Initially, Jimi's father, AI, inherited the rock star's $80 million estate. Unfortunately, this was only the start of further family drama surrounding wills. When Jimi's father died, his will left Jimi's fortune to Jimi's sister, Janie. This didn't sit well with Jimi's brother, Leon, who felt that he was entitled to about a quarter of the $80 million estate and sought to overturn his father's will. Judge Jeffrey M. Ramsdell of King County Superior Court upheld AI's will, leaving Leon with nothing. Instead, in accordance with AI's will, Janie inherited the estate. The situation was only further complicated by the fact that Janie had breached her duties as the trustee of Jimi's estate by not paying 10 family members the trusts that were created in AI's will. Equally as important to having a will is understanding the terminology that is used surrounding them and the rules that define them. As said earlier, intestate is when someone dies without a will. On the contrary, when someone creates a will, they are known as the testator. When they die, the person is said to have died intestate. Any legal issues arising from a will are handled in probate court. In the scenario where someone dies in intestate and has no living kin or heirs, their property titles will be transferred to the state. The action of title transfer to the state is called escheat. When someone gifts real estate in a will to another, it's typically called a device. The recipient of this device is called a devicee. When someone gifts personal property, it's called a legacy. The recipient of the personal property is called a legatee. Creating a valid will is actually relatively simple. The first step is creating an inventory of all of your assets. This will include personal property, real property, and accounts. After this, you must choose beneficiaries. These are the individuals or entities that you intend to give or pass on your assets to. The next step is the actual method of writing your will. There are a few different options. These include consulting an estate planning attorney. This is the best when someone has a diverse estate. This method will cost money, but will also ensure a legally sound will. There are also online resources to help ensure that a will meets state requirements. This is best for simple estates. The final method, and most convenient for the testator, are handwritten wills. There are few limitations to a physically written will. It can be on any physical surface and done with any writing instrument. The limitations, or requirements, for a valid will consist of a few important details. The will must be written in sound mind, also called testamentary capacity. This ensures that the testator must be of legal age and again of sound mind. Most states set the minimum age at 18 years. The will also must be signed by the testator for it to be valid. In addition, there's a witness requirement, which varies by state but typically entails having 2 to 3 mentally competent individuals witness the testator signing the will. These witnesses often must sign the will as well. This measurement is implemented to ascertain the mental capacity of the testator and to mitigate the possibility of coercion or undue influence. If this process is followed, a valid will has been created. It's always smart to keep a will in a safe place. This could be with a trusted individual or in a safe deposit box, for example.
A case where a valid will was not created or was deemed invalid due to a lack of testimony intent was in Middlestead versus Meriwether. The decedent, Jack, changed his will and beneficiary designations on bank accounts to leave everything to his half-brother. The decedent's sisters challenged these transactions for mental incompetence, and the jury found for the sisters. The half-brother then appealed. Dr. Adia, a medical professional who was designated to testify in the case, reviewed Jack's medical records, affidavits, and conducted interviews to assess Jack's mental and physical condition. He concluded that Jack suffered from multiple health issues, including at least one stroke, generalized anxiety, hypertension, and chronic alcoholism. Dr. Adia stated that Jack was incapable or had difficulty performing basic and instrumental activities of daily living. The court found Dr. Adia's testimony to be credible. While he didn't review every possible medical record, the court deemed his testimony admissible, stating that the weight of his testimony is determined by the extent of his review. The court defines testamentary capacity as the mental ability to understand the act of making a will, the extent of one's property, the natural objects of one's bounty, and the claims upon them. The pivotal issue in a will contest is whether the testator had testamentary capacity on the day the will was executed. Witnesses testified that Jack's mental state began to decline in 2018 and continued into 2019. Witnesses also described Jack's behavior as flat or difficult to engage with. Based on this evidence, the jury reasonably concluded that Jack lacked testamentary capacity at the time he executed the will. Documents executed by individuals lacking sufficient legal or mental capacity may be avoided. In summary, the court found that Jack was not of sound mind at the time he executed his will due to his declining mental state and various health issues, which impaired his cognitive abilities. Therefore, the will is subject to avoidance, and the court affirmed the trial court's judgment in favor of the contestant, Jack's sister.